Welcome to the Innovation Race podcast, where we meet fascinating inventors, innovators, politicians, and leaders who share the view that what's best for our country is to protect patents and keep innovation in America. Now, here's your host, Jenny Beth Martin.
Gary Lauder has been a venture capitalist since 1985 and has invested in over 150 private companies. He's also a co-inventor of 17 patents. He understands many of the topics discussed in the documentary film Innovation Race, and he has insights unlike any other we interviewed in the film. And now, during this podcast, you'll get to have a deeper dive on topics that we could not fit in the film. By the way, Innovation Race is available as a virtual cinema event for another week. To get tickets, go to innovationracemovie.com. And now I'm happy to introduce to you our friend, Gary Lauder. And we're really pleased to have you here today with us, Gary. Thank you so much.
My pleasure. Thanks for inviting me. And in particular, thank you for doing Innovation Race. That was excellent.
Well, thank you. Tell us a little bit about just your background and how you came to pay attention to the importance of patents.
Well, if I put it in chronological order, I was always fascinated with technology and science, and in one of my early birthday parties, a friend of mine gave me a book about inventors and their inventions, and I found that particularly fascinating. And I've always been kind of curious both about how things came about, but I'm an economics major, and so the incentive structures that make things come about has always been an important part of my thinking. And so as a venture capitalist, I'm also, I'm one of the people who receives those incentives, and that I am induced to invest in some things by the belief that this company will be successful, and that and often that patents could play an important part of that success. And to be clear, the way patents can be helpful is by helping prevent competition. And all patents are is a right to sue and be sued. And so they do not in any way guarantee success, but they help reduce the chance that if you created something great, that someone else can come along and copy the idea and put you out of business or reduce your sales and profits. So anyway, I've always just found the origin stories of many things, including inventions, to be really interesting.
And you've invested in over 60 companies, is that correct?
No, over 160.
Over 160. I missed the one in front of that. That is a lot of companies. What are a couple that maybe you are the most excited you've invested in?
Well, the one I like to talk about most because it's most interesting is ShotSpotter. They sell gunshot location services to the police. In many urban areas, both in the U.S. and overseas, they have gunfire problems. And in 80% of gunfire does not get reported to the police. And so they only hear about 20%. And then when they do hear about it, it takes a long time to get the address and to show up. And when they and it's very imprecise. And anyway, so they enable the police to respond quickly if there's outdoor gunfire, and that has where it's been properly implemented, that has reduced both gunfire and homicides by about 40%. And,
wow.
Yeah, and so it's. And one of the reasons I'm most proud of it is not only all those lives that have been saved, and those people whose lives were saved don't know it, but also this was an area that I knew nothing about before, and previously I'd been investing in things that I had some expertise in, and when I realized that I don't need to have prior expertise necessarily in all the areas that I invest, that was very liberating, and so I now invest in all kinds of crazy things.
Oh, wow. That's good, though, because sometimes people will have an idea that is going to be very profitable.
And nobody has, if it's new to the earth, it could be that nobody has expertise in it.
Right. Which is what oftentimes inventors are doing. They are thinking of things. That's the whole point. They have thought of, to get a patent, they have thought of something that no one else has thought of. It is new to the earth. And
yes.
I think that when you don't actually take a moment to step back and consider just how these are brand new ideas that no one has ever thought of, how amazing it is that we have people who walk among us who can think of those kind of things. When we were talking a few minutes ago before we got started, you talked about how one of the things about the incentives with inventors is that sometimes they're a little bit, some inventors are a little bit different people who maybe they don't think the same way as everyone else. And I don't mean that in any way as an insult to them. I mean it as I've never come up with an idea that no one else in the world, in the history of the world, has ever come up with. To be able to have that kind of talent and skill is very, very unique. It is unusual. And in our system of government has found ways to incentivize those people.
So to elaborate on that, it has been my observation, and I don't know that I'm the only one who's observed this, that many inventors are people who might not otherwise be employable or not so productively. So often technology entrepreneurs have a number of different diagnosable conditions like obsessive compulsive disorder, or I would say obsessive compulsive traits. They only become a disorder when they interfere with proper functioning. And there was, in fact, a wonderful book written called America's Obsessives. The compulsive people who built America, about many of the founders and creators of a lot of great companies had clearly obsessive compulsive tendencies. Steve Jobs among them. When I went to his home in 1989 or 1990, and there was no furniture, and it looked like he just moved in, but he'd had it for years. But apparently there was no furniture that he liked, and so he.
Wow.
So anyway, among the some of the entrepreneurs I've been associated with were bipolar, and many entrepreneurs have been dyslexic. There's a number of very high-profile, successful people who are dyslexic. And there's a wonderful book on how called The Mind's Eye. There are many books with that name, but one of them is about how dyslexics seem to also have more creativity and imagination, and their ability to imagine things as they could be, which is one of the reasons why they tend to invent more and be disproportionately represented among entrepreneurs. So so there's all sorts of things that might reduce someone's employability that increase someone's potential ability to invent but one of the reasons I mention that is that when we lose our patent system, which we're in the process of losing, we also lose the opportunities for people with all these differences to flourish. And
going back for just a moment to Steve Jobs, if you were working in a normal business with cubicles, not having furniture would be very odd and it wouldn't fit in, but he has invented things that have truly changed the way we function in everyday life, not just in America, but around the entire world with the advances to phones and smartphone technology.
Sure,
so,
right. He was, has been well documented, very obsessive about a lot of detail. Had he been your typical employee, he would have been fired for complaining about, minor details.
That is an interesting way to think about the patent system, though. The fact that we're giving these people who may not fit in otherwise with the normal kind of jobs that we think of the ability to create whole new markets and to flourish in ways that we can't even imagine with the status quo. Now we've hit on patents, and you just said that our patent system is being weakened. Go into a little bit about that. You have been following the patent system longer than I have, and you followed it as the American Invents Act became law. What kind of changes have you seen over the years from the way the patent system used to be versus the way that it is today? And not all the changes, I realize, are because of the law. Some are judicial in nature.
Yeah. So, as you mentioned, patents have changed due to a number of different causes. So, the changing the law, I would say, is a self-inflicted wound, and the Congress did this when it passed the America's Invents Act in 2011, and that made a number of changes. Changed our system from first to invent to first to file, which I can explain. But the worst aspect of it was it established something called inter partes review, which means Latin for between the parties review, and which established within the Patent and Trademark Office something called the Patent Trial and Appeal Board, the PTAB, and this basically means that it was sold as a faster and cheaper way to get rid of bad patents, but really that was a lie, because what it has been is an additional way for defendants to challenge any and all patents that they're sued with. And so anytime that there is a serious patent suit, and I say a serious one because there are nuisance suits where someone takes a patent that isn't really particularly good, and threatens to sue somebody with the goal of settling for something less than it costs to litigate. So there's those nuisance type suits, and this may reduce those, but any legitimate serious patent lawsuit, for example, Sonos was working with Google, and then ultimately Google knocked off Sonos's products after having been disclosed under non-disclosure, some of their innovations, and of course there's the patents that as well. So that this is a very serious suit, and so Google has challenged many of Sonos's patents in their attempt to defend themselves, in order to not only to drive up the expenses of the defendant, but also to these are like multiple swings at the piñata, because with enough swings, eventually you find a judge who misunderstands things and gets rid of various claims. All sorts of very legitimate patents have been eliminated there because of the non-expertise of the judges there. But just the fact that you get so many more swings at the piñata reduces the probability of good outcome, and it also delays the typical patent case by 1 to 2 years. So when someone sues, typically the judge will put a stay, meaning suspend the trial until there's an outcome at the PTAB, and so it adds years, it adds millions of dollars of defense costs, and it reduces the probability of a favorable outcome for the patent holders, and as a result, the value of patents is dramatically reduced. And so it is now a much more iffy proposition for any inventor to expect to effectively protect their inventions through patents. I don't discourage people from getting a patent on in general, because there are still many areas where it can help, but I would say that relying on it is it can no longer be relied upon wholly. So that means that more things need to be trade secrets that might otherwise have been patented. It also means that other means of being successful are important. For example, and when you're typically people who are inventing something new, they're creating something that hadn't existed before, and they need to minimize the time between when they've thought of it and going to market, because information leaks, and or also other people can come up with the same idea. And so if you can't rely on the patent, then you need to also rely on being first to market and having it be really good and not just the thing that other people copy and improve upon, and so forth. So anyway, so patents are no longer a source of strong. Well, they were, frankly, when I was in business school, I graduated in 1990, and I was shocked at the time when I was reading an article about first mover advantages. I was shocked that even then, when the patent system was strong, that it considered patents to be a weak form of competitive advantage relative to other competitors, and that's something that a lot of inventors don't get. Especially in the inventor community, many of them think that I got this patent and now I'm going to be a millionaire or whatever. That is so far from the truth, because you have to make something that people really want that's a lot better than what existed, and succeed in communicating and to people that they wanted, and then also keep out the competition through perhaps through a patent, or perhaps by just being really good at what you do. But the fact is, some industries are much more dependent on patents. Some types of technologies are much more dependent than others. So there are some where you got to try lots of different things before you get it right. And then once you do, then you sort of, let's say, for example, a new drug.
Mm-hmm.
I mean, the drugs have to be applied to the FDA, and there's all these public disclosures of what it is. If there were no patent protection, and generics could start making it the moment the drug was approved, then nobody would bother.
Right.
And so, I mean, and that's an extreme example, but there are many different types of things on the continuum, and so internet and software are pretty much the only areas of technology where you don't need patents, and where patents don't play much of a role. And it's no coincidence that big tech, which has been trying to undermine our patent system, are mostly internet and software companies.
Right. Okay, let's step back for just a second. When you said that, we're talking about, as an example, the drugs, pharmaceuticals, and you said if you just put it out there and you had to go straight to generic, mm-hmm. nobody would bother. I agree with that immediately, but explain it to someone who maybe doesn't understand that concept.
So when I say they wouldn't bother, the whoever created the drug, it takes a lot of time, effort, and therefore money to invest in the research and development of the drug, and then it takes orders of magnitude more money to put it through clinical trials on first on animals and then in humans, to see whether or not it does what one hopes, and it doesn't have adverse side effects. And the average cost. There's a wonderful book. An article, which many people have heard of Moore's Law, which is named after Gordon Moore, about how semiconductor density keeps improving over at an exponential rate. Well, there's something in the pharmaceutical industry that was called Eroom's Law, which is Moore's Law spelled backwards, and it shows how the dramatic increase in costs per drug approved by the FDA. When that article was written about a decade ago, the cost had been increasing at a exponential rate, and the cost at that time per drug approved by the FDA was $2.5 billion, billion with a B. So nobody's going to invest $2.5 billion per drug if it can be knocked off, and so.
If there's no way to recoup that cost, so that you can then go and do R&D for another.
Correct.
One.
Yeah, and this gets back to a large part of the problem with the perspective that many people have on the patent system is they don't understand how we got here, the incentive structures that existed that brought us to this place. People look around and they see things as they are, not understanding how they might otherwise have been in the absence of those things. And that's why I sometimes recommend to people to see what that's like, to go visit Cuba, where, due to the absence of property rights, without clear title and in real estate and so forth, they haven't really been building buildings very much since the revolution in 1959, and so and until a few years ago, they pretty much all the cars were from then too.
Right.
And so this is a place that was frozen in time. Now, right after the revolution, things looked the same in Havana as they did everywhere else. But roll forward 50 years, and you see that they're not. And it's a similar thing with respect to innovation in this country. Without a good patent system, then the innovations will start coming more and more from other places like China, who is getting their intellectual property system right.
Okay. The intellect. We'll go to China in just a moment, but I want you to elaborate on one other thing that you said. Mm-hmm. You said that a patent at the very beginning is nothing more than a right to sue and be sued. And most people would think, well, that is a bad thing. We don't want to deal with lawsuits and litigation. Explain how in this case, the ability to be able to do that, it protects your property. And that is an important aspect of it.
Sure. Yeah. Nobody wants lawsuits, and so what you really want for these things to do is to change the behavior of other people in society who might otherwise anticipate a lawsuit and therefore avoid that lawsuit. And so instead of copying your product, they go do something else, or they take a license. But what is happening instead is if a large company, for example, knows that if you were to sue them, you would probably not be able to get an injunction, meaning the court wouldn't necessarily allow you to prevent them from producing the product. Instead, these days, since the eBay versus Mercantile Exchange case in 1996, I think it was maybe 2006. It had to be 2006. Right. It wasn't invented. That case set the standards for what was necessary in order to get an injunction, and it's been widely misunderstood by courts to such that one can almost never get an injunction, and therefore the infringer only has to worry about monetary damages. And so as long as they reserve enough money to pay in the event that the plaintiff were to win, then they feel it's their fiduciary duty to go ahead and copy. There was actually an Apple executive who was quoted in The Economist saying that they feel that it's their fiduciary duty to copy. And that is just a travesty. And so it's not that we want lawsuits. What we want, the laws have to have teeth in order for people to have appropriate concern. And if you eliminate the ability for plaintiffs to succeed, then prospective defendants will therefore disregard the laws disregard the risks and go ahead and copy. And that's not it's in their interest. It's not in society's interest.
Because if you see that when you invent something, it's going to be copied and you get no benefit for it at all, mm-hmm. You, as an inventor, may wind up doing what I have heard inventors with patents tell brand new inventors: just lock it up in a file cabinet and don't let it see the light of day, because it's your baby and you're protecting your baby. That isn't the phrase they're using, but it's almost what they think. That way, at least no one can hurt your invention. But no one benefits from your invention either. Yeah,
I mean, if it's just going to be in a file cabinet, that is a waste. So, yeah, I mean, there is enormous frustration among inventors, appropriately so, and but it's not to say that one can't succeed at inventing and commercializing one's inventions. It's just harder.
Right.
And so, I mean, if you take the case of Dan Brown of Loggerhead Tools, which is a case that has been written about so widely, he created this wonderful invention of a wrench that you didn't have to. It was an adjustable wrench, so multiple hex sides, and you didn't have to like traditional wrench. You got to flip the thumb screw.
Right.
This thing you just grab and turn. Is a brilliant thing. And Sears was selling it, and being a patriotic American, he manufactured it in America. And even though it was somewhat more expensive, it was worth it to people who bought it and used it. And Sears went out and had it built for them by an affiliated company and manufactured in China. And undermined his pricing, and it was just a direct knockoff, is blatant and willful and intentional, and so in his case, he got screwed by them. There was lots of lawsuits. He won, and then ultimately he lost on appeal with no reason given in the appeal. So anyway, one cannot always expect justice from the courts, but in today's environment, if with a time machine, if I could go back and advise Dan, I'd say, it's great that you're trying to be a loyal American, but you know what? You'll get screwed over if you do that. So if you want to succeed, you need to try to get the least cost manufacturing you can, even if that means having those jobs be overseas. That's a way to adapt.
Right.
It's not what I wish were the case, but that is so. And I do think we need to bring back manufacturing capability in this country, but the point is that there are things one can do differently that where one could survive in this environment. It's not, I wouldn't say all hope is lost. I would say that it's harder.
And you've got to look at the entire business situation,
Mm-hmm.
so that you can find a way to be able to succeed given the rules that are in place at the moment. We can still work to make the system better, but you also have to look at where we are right now and adapt and live in the moment.
Yeah, and I would just want to, I mentioned before that the Americans Invents Act changed our system from first to invent to first to file. Let me explain what that means. So what it means is that if two people claim to have invented the same thing, in the old system, the way that the patent office would adjudicate that issue, which rarely ever happened, like 1 out of every 200,000 patents, both parties would come in and have to present their evidence of when they invented it. And so at the time, therefore, inventors were advised to keep notebooks and records that could prove where they were at what stage in their inventions. Under first to file, all that doesn't matter. The only thing that matters is when whoever gets to the patent office first, and that has been a huge gift to intellectual property thieves. And given the cybersecurity threats we're under, to throw that giant of a bone to people who might otherwise hack Americans is just bonkers, and that was not considered. And I wrote about this, and when I shared it with lots of cybersecurity experts a decade ago, and none of them were aware of this issue at all. Nor were the people who are voting on this issue. But
because we're creating a perverse incentive that says steal somebody else's idea and you can be the beneficiary of it.
But it's not just a matter of hacking. I mean, because one thing that's not generally appreciated by those who advocated for this is that for an entrepreneur to commercialize their invention, they have to find other employees, and they need to disclose what they're doing to them. They need to find suppliers who are typically serving the same industries as the prospective competitors, who could directly copy what they're doing. They go to advertising agencies, and there's all these different parties. A manufacturer, there's all these different parties that they need to share what they're doing with, any of whom could violate that person's, even if they have a non-disclosure agreement. If you can't prove it, then there's no action that can be done.
With all of the different research I've done on this, I don't think that I've heard anyone else talking about the warning that would come with the hacking. And it may seem far-fetched to some people who are listening to this, but if you're a big company who has the ability to make millions, if not billions, off of what someone else is coming up with that has never been thought of in the history of the world before, there's a lot at stake, and there are a lot of sometimes perverse incentives to be able to grab hold of that.
Yeah. And so let me just elaborate a little bit more which is that also another change in the brought about by the American Invents Act is that a change in what is called the grace period. Under the prior grace period, you had 1 year from a public disclosure or offer for sale of your invention. So you could go to a trade show and see if the dogs would eat the dog food. And you could demonstrate your widget. Under the AAA, if you go in front of, let's say, Shark Tank, and you say, "Here's how it works,"
right?
At that point, if you haven't already applied for a patent, then you can't. Presently, the law is now that if you publicly demonstrate your product, then your own disclosure becomes the prior art against your own invention, and you cannot patent that which you publicly disclosed. Or similarly, if you offer to sell it, then that also is an immediate bar on patenting that. And so, and these are among the many different hidden tripwires that exist under this awful act, which I believe should be repealed. And Representative Massey has a bill to do that, and I am enthusiastic about it. I'm not optimistic about it, but I'm enthusiastic about it.
Right. I think that you have to have bills like Congressman Massey's out there to say this is the ideal world. And even if we wind up in a situation where we don't get the ideal world and we can get an improvement over the system as it is right now, we're going to be in a lot better shape.
Yeah. I think if you were to ask most patent professionals, I think they would say, yes, we should just get rid of it because it's just so bad on so many levels. Unfortunately, they're not the ones who get to vote on that.
And they also, most of them don't have the same kind of money for lobbying firms that the ones who want to keep it in place have.
That is correct. There was, circa 2010, there was an article in the Washington Post about how the forces of darkness spent over $100 million lobbying this issue.
It's $100 million. It is an enormous amount of money.
Yeah.
An enormous amount of money.
Yeah.
But that tells you how much they think is at play if they can control how the patent system works, and they're able to be the first to file, and they can just sue people or bring the cases before PTAB over and over until the patent goes away.
Right. I should add that that one thing that they don't do is they don't tend to use the patent system proactively. I'm unaware. I am aware of one case where Apple, an inventor entrepreneur whom we both know, it disclosed something to Apple, and then Apple had the chutzpah to actually file on it. But I think that's more rare. But they tend not to proactively sue for patent infringement, but they are very hyperactive with respect to their defense, and that is a huge problem for anybody. And I should add, this should be there is inadequate understanding among the antitrust enforcers in this country about how the abuse of one's giant balance sheet to be, to go after any plaintiff from a patent perspective is, I think there ought to be some antitrust action on that, because it's what they're trying to do is not only cause that particular plaintiff to go away, but they're trying to send a message to all other prospective plaintiffs. This is what will happen to you if you choose to sue us.
Right.
And this is not just.
No, it's not. And when they have $100 million in reserves, just in cash reserves, they are able to do things that other companies simply, especially very small inventors, there's no way they can defend against that much money. And I guess that's not a fair thing to say. There are ways to defend against it, but it is a very difficult, very expensive future for them. And when you were talking much earlier about the piñata effect, just going and swiping it, hitting it, whacking at the patent until it goes away, while they are whacking at the patent, they're running out the time, because what the Constitution says is that the inventor or the owner of the intellectual property has exclusive right for a set period of time. In our country right now, it is 20 years.
From the date of invention. And since the time that they passed that law, the time it takes to get to receive your patent after applying has grown substantially.
And isn't it about 3 years right now from when you?
I think it's more like 4.
Wow.
And at the time that was passed, it had been 18 months.
So when it passed, at 20 years, you're already dealing with 18 and a half years, but now you're dealing with 16 years.
Right.
And then they start filing in PTAB against you, which could be 2, 4, 6, even 10 years of defending that. So you wind up with just a handful of years left.
Patent lawsuits do sometimes take a decade. Yes, and that I should also add, that's an average number to receive a patent, but if you look at the dispersion on that, it can there's a long tail on the distribution of how long it takes. It can be as much as 12 years to receive a patent. Now that's rare, but that happens, and they changed the law for a good reason, because prior to that time, there were what were called submarine patents, where the patent applicant would keep modifying their patent and tweaking it in lots of ways that caused it to never issue from the patent office, and all the while the technology that would become more and more sort of out there in the world. And then it would pop up, and suddenly all these people who were infringing didn't know that they were infringing, and so it was a reasonable solution to that problem. But there's this other problem and part of the problem is the patent office is not given enough resources to hire and retain and incentivize enough examiners to clear the queue. And so there should not be any queue, in my opinion.
Especially when you have such a short time to have exclusive ownership of your own idea that no one else in the entire history of the world had ever come up with before.
And for another good reason, which is that a lot of people complain about patent trolls, which are it's a pejorative term that there are different types of patent plaintiffs. So there's to me the best kind of plaintiffs are ones where inventor invents something, tries to make it, has a company, has a product, gets knocked off, etc. then you sometimes have a situation where the company fails, and then the assets are taken over by somebody else, and so and whoever received those assets winds up suing the parties, and often that's a way of getting justice on behalf of the people who are driven out of business. But it's also the case that sometimes there are people who have patents that are kind of worthless, and they're just being nuisances, and so and those might be the only ones worthy of being called a troll. But of course, all defendants call their plaintiff a troll.
Right.
But anyway, the key an important concept here is this notion of the patent being a transferable right. There have been a number of bills to try to limit, and in fact, some inventor groups are trying to have the inventors have more rights in court than somebody who didn't invent it. Somebody who bought the patent. I think that's a really bad idea, because anyone who's investing in developing in the company that's developing the concepts behind the patents, they need the value, the full value of whatever the patent is, to be vested with the company, irrespective of whether or not the inventor is still at the company or not at the company.
Right.
As we've talked before, inventors sometimes don't make great employees. And so there's something in the venture capital industry called founderitis, where often the founders are difficult people who have conflict with the other employees and don't wind up staying. But so you can't. I think you don't want to confer excessive value of that person staying with the company for the purpose of the lawsuit. I mean, there's just all sorts of ill-considered ideas to improve our systems.
So you've hit on really big pharma a few times. Did I hear you say that they initially were in favor of the America Invents Act?
Well, it's an interesting issue.
Because
the America Invents Act was basically a very long-term battle of the giants between the big tech that didn't like patents, and it's not all tech, the big companies that didn't like patents, and pharma, who did. And unfortunately, there aren't always only two sides to a situation. Often there are other sides, 3, 4, or however many. And that negotiation did not include the interests of small companies.
Okay.
And so in fact, in the last patent speech that I gave, you may recall that the title of that speech was the role of patents, and I spelled role R-O-L-L, not R-O-L-E, the way it's supposed to be spelled, because the interests of patent holders got rolled,
right?
And I am unable to say whether it was intentional or unintentional. But but the interests were disregarded, and so it was a compromise. But in the process, the interests of smaller patentees have been dramatically reduced.
I have found myself a few times in an interesting situation, because I don't always think everything that big pharma does is a good thing, and yet there have been attempts, especially with the COVID vaccine, to say, well, then you just can't profit from your patent at all, and they want to just.
You're talking about the TRIPS waiver?
Yeah. And I've defended the right to be able to have their patent, and it's not. It doesn't mean they can't still just give it to the world if that's what they choose, but I think I think we have to be very careful. We can't just ignore property rights or human rights in the time of pandemics. You still have to pay attention to them.
Yeah, no, I agree. And the TRIPS waiver is it's a complicated issue. I don't have a lot of expertise on it, but I have, I think, more than your average listener. So the and that's so it stands for trade-related intellectual property something, and the basically it's an agreement among many countries to respect intellectual property rights, the issue was about vaccines, and the whole thing was just there were some op-eds written by I think the CEO of Pfizer and so forth that explained pretty effectively how it was all BS, and that firstly the intellectual property, the patent rights under it wasn't the obstacle to anyone manufacturing.
Right.
There was a lot of know-how and trade secrets associated with the manufacturing of this, without which those patents were worthless. And so effectively nothing has been accomplished by that. And it is also the case that the vaccine makers licensed many other people to make the vaccines. And so they were trying to scale up manufacturing globally to meet the global supply. So, I think that it was largely a ploy by countries that have large generic makers to try to further weaken patents. And now you can see before the WTO is now considering extending TRIPS.
Right.
So just as predicted, they're trying to manipulate it to cover other stuff for the future.
Right. Once they get their claws in, or the nose and the camel's nose and the tongue.
Can you imagine, like if it is always the case every time a pandemic comes along that they're going to waive your intellectual property rights? Who would invest in developing the vaccines and drugs to try to help solve for the next one? I mean, this is a multi-round game, and so one needs to always consider the effects in the present on what one does in the future. In a similar way, I thought it was bonkers under the past administration that we restricted Qualcomm from selling chips to China, because that means other countries would then therefore think twice about buying chips from U.S. makers in the future. They're often government does not think many steps ahead in their policies, and so. I tend to be, as a former economics major, I have very free market tendencies, and I don't think the government should be restricting trade, except to deal with, specific sets of externalities and malfunctions. Antitrust is one type of malfunction, and externalities like pollution is another.
And I think you also have to, you mentioned we do need to have more manufacturing here in America. I think we have to think about national security implications as well.
Absolutely.
That's making sure that we're looking out for the interest of America.
Absolutely.
In those.
And that's an important reason why we need to bring back manufacturing capability in this country.
Right. Well, this has been a very interesting conversation. I think there are several different links that I'm going to get from you. You mentioned 2 different books. You mentioned an article from The Economist and a couple of others that we'll make sure we get those links so we can include them in the description of this. And it's just fascinating conversation. I'm so glad you've given time today for this podcast and to participate in the documentary. And most importantly, just being such a huge advocate for the inventors and the companies you invest in, and the companies that maybe you don't invest in, but you still want them to be able to have the ability to invent and make the world better.
Well,
so thank you.
And thank you. Your organization has now sponsored 2 wonderful documentaries, both Invalidated and also recently Innovation Race. And they're both excellent and a great service to this country. And I hope that everyone gets a chance to see them.
Well, thank you very much. And thank you everyone who has been listening and watching this podcast. I'm Jenny Beth Martin with Tea Party Patriots Action and the executive producer of Innovation Race. And our guest today was Gary Lauder. Thank you. Our film, Innovation Race, is now available as a virtual cinema event. For more information about the documentary, go to innovationracemovie.com.
The Innovation Race podcast is hosted by Jenny Beth Martin and produced by Kevin Mooneyhan, Lori Heiselman, and Andy Peterson. Luke Livingston directs the video podcast. Innovation Race podcast is a production of Tea Party Patriots Action. For more information, visit teapartypatriots.org. That's teapartypatriots.org.